Hey guys, welcome back to our new video. I am teaching you the Customs Act 1962, Act 52 of 1962, which is implemented from 1st February 1963. And in the last some videos, we have seen up to the section number 28 and chapter number 5 we are seeing right now. And in the same, we have seen 17 sections. Now in the last section 28 there are subsections also, and in this video we are going to see these subsections. So guys, I am Mangesh Hande teaching you the Customs Act 1962, giving information to you in this video about the sections. So guys, in the previous videos we have seen the sections. Section number 12, dutiable goods. Section number 13, duty on pilfered goods. Section number 14, valuation of goods. Section number 15, rate of duty on and tariff valuation of imported goods. Section number 16 is of rate of duty and tariff valuation of export goods. Section number 17 is of assessment of duty. Section number 18 is of provisional assessment of duty. Section number 19 is of determination of duty, where goods consist of articles liable to different rates of duty. Section number 20 is re-importation of goods manufactured or produced in India. Section number 21 is goods derelict, break, etc. Section number 22 is abatement of duty on damaged or deteriorated goods. Section number 23 is a remission of duty on lost, destroyed or abandon of goods. Section number 24 is of power to make rules for denaturing or mutilation of goods. Section number 25 is of power to grant exemption from duty. Section number 25A is of inward processing of goods. Section number 25B of outward processing of goods. Section number 26 is of refund of export duty. Section number 26A is of refund of import duty. Section number 27 is of claim for refund of duty. Section number 27A is of interest on delayed refunds. Section number 28 is of recover of duties not levied, short paid or erroneously refunded. Section number 28A is of power to not to recover duties short paid, short levied as a result of general practice. So, in the section number 28A, power not to recover duties not levied, short levied as a result of general practice. In the same, where there is mentioned that subsection 1, notwithstanding anything contained in this act, if the central government is satisfied, clause A, that practice was or is generally prevalent regarding levy of duty, including not levy thereof, on any goods imported into or exported from India. And clause B, such goods were or are liable, subclause first, the duty in cases where according to the said practice the duty was not or is not being levied, or subclause second, to a higher amount of duty than what was or is being levied according to the said practice. Then the central government may, by notification in the official gazette, direct that the whole of duty payable on such goods, or as the case may be, the duty in excess of that payable on such goods, but for the said practice, shall not be required to be paid in respect of the goods on which the duty was not or is not being levied, or was or is being short levied in accordance with the said practice. in the subsection 2, where any notification under subsection 1 in respect of any goods has been issued, the whole of duty paid on such goods, or as the case may be, the duty paid in excess of that payable on such goods which would not have been paid if the said notification had in force, shall be dealt with in accordance with the provisions of subsection 2 of section 27. Provided that the person claiming the refund of such duty, or as the case may be, excess duty, makes an application in this behalf to the Assistant Commissioner of Customs or Deputy Commissioner of Customs in the form referred to in subsection 1 of section 27 before the expiry of 6 months from the date of issue of the said notification. So section number 28A is a power to not to recover duties of short levied as a result of general practice. In the section number 28AA, interest on delayed payment of duty. Section 28AA is of interest on delayed payment of duty. Subsection 1, notwithstanding anything contained in any judgment, decree, order or direction of any court, tribunal, order or any authority or any of the provisions of this act or the rules made thereunder, the person who is liable to pay duty in accordance with the provisions of section 28 shall, in addition to such duty, be liable to pay interest, if any, at the rate fixed under subsection 2, whether such payment is made voluntarily or after determination of duty under that section. Subsection 2, interest at such rate not below 10%, not exceeding 36% per annum, as the central government may by notification in the official gazette fix, shall be paid by the person liable to pay duty in terms of section 28, and such interest shall be calculated from the day of the month succeeding the month in which the duty ought to have been paid, or from the date of such erroneous refund, as the case may be, up to the date of payment of such duty. So in the subsection 2, there is clearly mentioned that the interest rate should be payable from 10% to up to 36% per annum. And in the current scenario, central government has fixed the interest rate 15% on the delayed payment of duty. Subsection 3, notwithstanding anything contained in subsection 1, no interest shall be payable where clause A, the duty becomes payable consequent to the issue of an order, instruction or direction by the board under section 151A. Clause B, such amount of duty is voluntarily paid in full within 45 days from the date of issue of such order, instruction or direction, without reserving any right to appeal against the said payment at any subsequent stage of such payment. So in some conditions, there is clearly mentioned that interest should not have to be paid. What are these conditions? Clause A, if board has given any notice, directions, instructions under section 151A. And in the clause B, if any amount of duty is voluntarily paid within 45 days from the date of issue of such order, notification. So in that case also interest should have not to be paid by the importer. Section 28 AAA, recovery of duties in certain cases. Section 28 AAA. So we have seen section 28, section 28A, 28 AA, and now 28 AAA. Recovery of duties in certain cases. So in the section 28 there are many subsections. Mainly first section number 28 is a recovery of duties not levied, short paid or not paid or erroneously refunded. And section 28A is of power not to recover of duties short paid, short levied as a result of general practice. Section 28 AA of interest on delayed payment of duty. And section 28 AAA is of recovery of duties in certain cases. Subsection 1 in the section 28 AAA recovery of duties in certain cases is clearly mentioned that where an instrument issued to a person has not been obtained by him by means of subsection 1, where an instrument issued to a person has been obtained by him by means of clause A, collusion. Collusion means any मतलब किसी पर्सन के साथ मिली भगत से. क्लॉज बी, willful misstatement. क्लॉज बी, willful misstatement means हिंदी में आप कह सकते हैं कि जानते हुए उन्होंने वो रॉन्ग डिक्लेरेशन दिया, उसे यहाँ पे वर्ड दिया है willful misstatement. Clause C, suppression of facts. Suppression of facts means एनी पर्सन के दबाव में आके अगर कोई कृत्य करता है तो उसे यहाँ पे बोला गया है suppression of facts. So in the subsection 1, where an instrument issued to a person has been obtained by him by means of collusion, willful misstatement or suppression of facts for the purposes of this Act or the Foreign Trade Development and Regulation Act 1992, for any other law or any scheme of the central government, for the time being enforced by such person or his agent or employee, and such instrument is utilized under the provisions of this Act or the rules or regulations made or notifications issued thereunder by a person other than the person to whom the instrument was issued, the duty relatable to such utilization of instruments shall be deemed never to have been exempted or debited, and such duty shall be recovered from the person to whom the said instrument was issued, provided that action relating to recover of duty under this section against the person to whom the instrument was issued shall be without prejudice to an action against the importer under section 28. Explanation first. For the purposes of this subsection, instrument means any scrip, authorization or license or certificate or such other document by whatever name called issued under the Foreign Trade Development and Regulation Act 1992 or duty credit issued under section 51B with respect to a reward or incentive scheme or duty exemption scheme or duty remission scheme or such other scheme bestowing financial or fiscal benefits which may be utilized under the provisions of this Act or the rules made or notifications issued thereunder. So instruments means any duty remission scheme, duty exemption scheme or reward or incentive schemes, whatever the schemes issued to him, in the same instruments meaning has been given. So Explanation 2. The provisions of this subsection shall apply to any utilization of instrument so obtained by the person referred to in this subsection on or after the date on which the Finance Bill 2012 received the assent of the President, whether or not such instrument is issued to him prior to the date of the assent. Subsection 2. Where the duty becomes recoverable in accordance with the provisions of subsection 1, the person from whom such duty is to be recovered shall, in addition to such duty, be liable to pay interest at the rate fixed by the central government under section 28AA, and the amount of such interest shall be calculated for the period beginning from the date of the utilization of the instrument till the date of recovery of such duty. Subsection 3. For the purposes of recovery under subsection 2, the proper officer shall serve notice to the person to whom the instrument was issued, requiring him to show cause within a period of 30 days from the date of the receipt of the notice as to why the amount specified in the notice, excluding the interest, should not be recovered from him, and after giving that person an opportunity of being heard, and after considering the representation, if any, made by such person, determine the amount of duty or interest or both to be recovered from such person, not being in excess of the amount specified in the notice, and first order to recover the amount of duty or interest or both, and the person to whom the instrument was issued shall repay the amount so specified in the notice within a period of 30 days from the date of receipt of the said order, along with the interest due on such amount, whether or not the amount of interest is specified separately. Subsection 4. Where an order determining the duty has been passed under section 28, no order to recover that duty shall be passed under this section. Subsection 5. Where the person referred to in subsection 3 fails to repay the amount within the period of 30 days specified therein, it shall be recovered in the manner laid down in subsection 1 of section 142. So, in the section 142, there is power to the Assistant Commissioner or Deputy Commissioner of Customs to recover the duties. So, section number 28 AAA is of recovery of duties in certain cases. So friends, now the section number 20B, duties collected from the buyer to be deposited with central government. Section number 28B is duties collected from the buyer to be deposited with central government. So till time in the section 28 we have seen section 28, recovery of duties, short levied, not levied, or short paid or not paid, or erroneously refunded. Section number 28A is of power to not recover duties of short levied, short paid as a result of general practice. Section 28AA of interest on delayed payment of duty. Section 28 AAA is of recovery of duties in certain cases. Section number 28B is of duties collected from the buyer to be deposited with central government. Subsection 1. Notwithstanding anything contained to the contrary, contained in any order or direction of the appellate tribunal, national tax tribunal, or any court, or any other provisions of this act, or the regulations made thereunder, every person who is liable to pay duty under this act and has collected any amount in excess of the duty assessed therein, or determined or paid on any goods under this act from the buyer of such goods in any manner as representing duty of customs, shall forthwith pay the amount so collected to the credit of the central government. Subsection 1b. Every person who has collected any amount in excess of the duty assessed or determined or paid on any goods, or has collected any amount as representing duty of customs on any goods which are fully exempt or are chargeable to nil rate of duty from any person in any manner, shall forthwith pay the amount so collected to the credit of the central government. Subsection 2. Where any amount is required to be paid to the central government under subsection 1 or subsection 1st A, as the case may be, and which has not been so paid, the proper officer may serve on the person liable to pay such amount or notice requiring him to show cause why he should not pay the amount as specified in the notice to the credit of the central government. Subsection 3. Proper officer shall, after considering the representation, if any, made by the person on whom the notice is served under subsection 2, determine the amount due from such person not being in excess of the amount specified in the notice, and thereupon such person shall pay the amount so determined. Subsection 4. The amount paid to the credit of the central government under subsection 1 or subsection 1st A or subsection 3, as the case may be, shall be adjusted against the duty payable by the person on finalization of assessment or any other proceedings for determination of duty relating to the goods referred to in subsection 1 and subsection 1A. Subsection 5. Where any surplus is left after the adjustment made under subsection 4, the amount of such surplus shall either be credited to the fund and or, as the case may be, refunded to the person who has borne the incidence of such amount in accordance with the provisions of section 27, and such person may make an application under that section in such cases within 6 months from the date of the public notice to be issued by the Assistant Commissioner of Customs for the refund of such surplus amount. In the section number 28BA, provisional attachment to protect revenue in certain cases. Section 28BA, provisional attachment to protect revenue in certain cases. Section number 28B, we have seen duties collected from the buyer to be deposited with central government. Section number 28 BA, provisional attachment to protect revenue in certain cases. And in the section 28BA, subsection 1 is where during the pendency of any proceedings under section 28 or section 28 AAA or section 28B, the proper officer is of the opinion that for the purposes of protecting the interest of revenue, it is necessary so to do, he may, with the previous approval of the Principal Commissioner of Customs or Commissioner of Customs, by order in writing, attach provisionally any property belonging to the person on whom notice is served under subsection 1 or subsection 4 of section 28 or subsection 3 of section 28 AAA or subsection 2 of section 28B, as the case may be, in accordance with the rules made in this behalf under section 142. Section 2 of section 28BA, provisional attachment to protect revenue in certain cases, states that every such provisional attachment shall cease to have effect after the expiry of a period of 6 months from the date of the order made under subsection 1, provided that the Principal Chief Commissioner of Customs or Chief Commissioner of Customs may, for reasons to be recorded in writing, extend the aforesaid period by such further period or periods as he thinks fit, so however that the total period of extension shall not in any case exceed 2 years. Provided further that where an application for settlement of case under section 127B is made to the Settlement Commission, the period commencing from the date on which such application is made and ending with the date on which an order under subsection 1 of section 127C is made shall be excluded from the period as specified in the preceding provision. Section 28BB, time limit for completion of certain actions. Section 28BB, time limit for completion of certain actions. Subsection 1. Any inquiry or investigation under this Act culminating in the issuance of a notice under subsection 1 or subsection 4 of section 28 shall be completed by issuing such notice within a period of 2 years from the date of initiation of the audit, search, seizure, or summons as the case may be, provided that the Principal Commissioner of Customs or the Commissioner of Customs may, on sufficient cause being shown and for reasons to be recorded in writing, extend the said period to a further period of 1 year. Subsection 2. For computing the period under subsection 1, the period during which stay was granted by an order of a court or tribunal, or the period of seeking information from an overseas authority through a legal process, shall be excluded. Explanation: for the removal of doubts, it is hereby declared that nothing contained in this section shall apply to any such proceedings initiated before the date on which the Finance Bill 2021 receives the assent of the President. So in the subsection 28 we have seen there is section 28, power to recover of duties not levied, short-lived, short-paid, or erroneously refunded. Section 28A is of power not to recover of duties short-lived, short-paid as a result of general practice. Section 28AA, interest on delayed payment of duty. Section 28AAA, recovery of duties in certain cases. Section 28B, Section 28B is of duties collected from the buyer to be deposited with central government. Section 28BA, provisional attachment to protect revenue in certain cases. Section 28BB, time limit for completion of certain cases. So these are the sections which we have seen till time in the chapter number 5, levy of and exemptions from customs duty. So we have seen in the chapter number 5 there is 17 sections, and in these 17 sections there are also section 28A, AA, AAA, that type of sections also we have seen. So once again I am repeating these sections for you for your better understanding. So section number 12 is of dutiable goods. Section number 13 is of duty on pilfered goods. Section number 14 is of valuation of goods. Section number 15 is for date for determination of rate of duty and tariff valuation of imported goods. Section number 16 is of date for determination of rate of duty and tariff valuation of export goods. Section number 17 is of assessment of duty. Section number 18 is of provisional assessment of duty. Section number 19 is of determination of duty where goods consist of articles liable to different rates of duty. Section number 20 is of re-importation of goods produced or manufactured in India. Section number 21 is of goods derelict, break, etc. Section number 22 is of abatement of duty on damaged or deteriorated goods. Section number 23 is of remission of duty on lost, destroyed, or abandon of goods. Section number 24 is of power to make rules for denaturing or mutilation of goods. Section number 25 is of power to grant exemption from duty. Section number 25A is of inward processing of goods. Section number 25B is outward processing of goods. Section number 26 is of refund of export duty in certain cases. Section number 26A is of refund of import duty in certain cases. Section number 27 is for claim for refund of duty. Section number 27A is of interest on delayed refunds. Section number 28 8 is of recovery of duties not levied, short paid, or erroneously refunded. Section number 28A is of power not to recover of duties short paid as a result of general practice. Section number 28AA is of interest on delayed payment of duty. Section number 28AAA of recovery of duties in certain cases. Section number 28B is of duties collected from the buyer to be deposited with central government. Section number 28BA is of provisional attachment to protect revenue in certain cases. And section number 28BB is of time limit for completion of certain actions. So these all sections are which we have seen in this chapter number 5, levy of an exemption from custom duties. So guys, this chapter number 5 is very important in terms of the Customs Act 1962 and in terms of the custom broker licensing regulations. So we have to do thoroughly study of these sections of chapter number 5, levy of an exemption from custom duties. Guys, I'm creating these videos for the working professional who are not able to read the books on daily basis. So while traveling or doing driving, they can listen these videos and improve their knowledge in the custom clearance, in the Customs Act 1962, and in the import or export. So the working professionals who are also doing work in the import or export activities, they can also watch these videos to expand their knowledge regarding the customs clearance. So my humble request to all of you that please like, share and subscribe to my channel and share with your friends who has required this info. Thank you guys for watching this video. We'll meet you in the next video with another chapter and another sections. Till time, bye bye and take care.